Hello my beautiful friend and welcome back to another daily video. Today we're gonna talk a little bit about Nintendo's summoning patent with a little bit of clarification because I promised you that I'm going to do that, and luckily we have not only this article but something else as well for that one. This is an article, as you can see, not written by, but published on Windows Central and is written by Jennifer Young. The patent office made a huge mistake. How Nintendo's problematic summoning patent passed without scrutiny. The controversial summoning a character patent acquired by Nintendo has raised uproar, and here's why it was allowed to happen. Well, at least the uproar was with people who, well, have a working prefrontal cortex and are fed up with Nintendo. So the sunk cost fallacy has already shifted so that they can see what Nintendo's up to. Then, earlier this week, with the help of a fantastic report from GamesFray, we covered the news of Nintendo securing a new US patent that not only looks like a part of their arsenal against Pocket Pair's Palworld, but could also send shockwaves across the wider gaming industry, which hopefully is going to be something, because we have Square with Final Fantasy, we have Atlas with Persona, we have Bandai with Digimon, we have Capcom with Monster Hunter Stories, and so on. I'm of course talking about the patent for summoning other characters to fight for you in a game, otherwise known as patent number 12.403.397. I've been following the back and forth between Nintendo and Pocket Pair since the original lawsuit in Japan, and I don't think I've ever seen this much attention on a Nintendo patent filing. And with good reason. It's insanely broad. It's certainly not something Nintendo invented, and most people are baffled at how the US Patent and Trademark Office, USPTO, granted it in the first place, and no one really understands that. I'm not the only person who thinks that money was a little bit shifted from person to person, but yeah, that's just speculation. Thankfully, amid all the uproar, Florian Mueller, the patent and gaming litigation expert behind GamesFray, we already read an interview by Florian a couple of weeks ago when the mount patent was changed. But yeah, he sat down for a podcast with Fritangaplays to break down exactly how Nintendo managed to push this patent through the USPTO. His take on the documents and the tactics involved is a fascinating listen. I highly recommend checking out the full episode, but for now I've pulled together the juiciest highlights below. I've watched half of it, but I still have to listen for, well, the rest. In the interview, Florian Mueller, I hope that it's a German name because I'm pronouncing it a German way right now, says that in his opinion, the patent shouldn't have been approved at all. I think I should not have been granted. It should not have been granted. The patent office made a huge mistake. The patent's wording from the start is deliberately vague. Storage medium, information processing system, information processing apparatus, and game processing method could describe virtually anything. That is what I also said. From AI systems to self-driving car controllers or even word processors. So, and this is here right at the, well, this page at the beginning. While Claim 1 describes a non-transitory computer-readable medium storing a game program, Mueller refers to his as boilerplate, an attempt by Nintendo to make the patent appear as technical invention. Simply submitting patent this game rule would have been rejected outright, so the language is deliberately obfuscated, which it is. Even we, the regular gamers who are not in law, can see this, which makes it even more ridiculous that this got through. For the patent to hold legal weight, each claim, starting with claim 1 and continuing onward, must be infringed. There is no dispute over the so-called storage medium. Any video game running on a console or PC obviously satisfies that element, making the first words essentially meaningless. The meat of the patent lies in the broader gameplay mechanics, particularly the system for summoning characters to battle. If you look at how broad the language is, this is not limited to Pokemon. For example, performing control of moving a player character on a field in a virtual space based on a movement operation input. So, what we should not forget is also, I don't know why my mind goes, no, of course I know why my mind goes into that one, is in World of Warcraft, when you play the hunter, you have a pet, and so on. This is a mechanic in a lot of MMOs. Final Fantasy has that with Summoner and with the Scholar, but yeah. The patent even covers positioning relative to enemy characters. The combination of summoning sub-characters and positioning is what gives the patent its potential reach. That means mechanics in games like Final Fantasy could technically fall under the patent, even though they predate Pokemon-style summons. Legal interpretation, Mueller notes, she even writes Müller with an umlaut here. So is he German? I have to look that up. Could be messy. Courts might debate what counts as a sub-character or a field, and whether a 2D grid could qualify as a virtual space. Even if a game is technically different, it might still risk infringement, he warns. Yet despite the patent's broad wording, Müller believes the actual risk to developers is limited, which is a good thing. But still, Nintendo is on a warpath here, I think. Palworld will continue mostly unaffected. The broad enforcement scenario that people fear probably won't materialize, he says. And again, Florian Mueller does know what he's talking about. Awareness, he stresses, is key. Monitoring patents and understanding prior art can help developers navigate the potential minefield. This patent would fail under even mild scrutiny, but that's not the point. Even if the patent wouldn't survive a court challenge, it has immediate consequences. Litigation is expensive, even if you're right. Even if you're confident you would win, you still have to spend millions fighting the lawsuit. And for smaller developers, that's not an option. They'd rather settle or change their game design than face that risk. And this is exactly the thing Nintendo is doing right now. They're the bullies at school, and they're using in their way now, their muscles, which means their money. Both of them starts with an M, so it fits. They're just a financial powerhouse here. And again, if you're a small indie dev, not even Team Cherry with Hollow Knight and Silksong could get against Nintendo, even though they are incredibly successful right now. In other words, Nintendo probably already knows it won't win every lawsuit, but the existence of the patent alone will deter competition. So, the question remains, how did such a broad gameplay mechanic, one that is within hundreds of other games, get through the USPTO without question? Oh, thank you. I was really hoping that this will come up. But again, this is exactly that. Smaller developers, smaller publishers have no chance to go against, and Nintendo is basically just paving their way to mediocre or just really incredibly bad Pokemon games for the future. The examiner probably didn't fully consider the scope of prior art in video games, or didn't fully grasp how common summoning mechanics already were, notes Müller. Now again with UE. Patent law wasn't originally designed with video games in mind. A lot of terminology and concepts from hardware or software patents. So when game companies file something like this, it can slip through the cracks because the examiner doesn't have deep gaming knowledge, which is also something really bad, but we have a lot of old pencil pushers there. But I still think I'm a little bit here. Okay, let's just say it this way. Tinfoil hat theory. I still think that there was money exchanged here. Something happened in the background. But it might not have been. The probability is still the examiner doesn't have deep gaming knowledge. That doesn't excuse this, because why is there just one person or maybe two persons who are looking through this, especially when it's a gaming thing? Shouldn't there be someone who understands this? You're also not going to let someone patent, I don't know, heated car seats, and you put someone there who doesn't know anything about cars and just says you have the patent, I don't know, BMW, or why do I say BMW? I'm also now BMW. So, or Audi or Mercedes or whatever, Porsche. There are so many companies that could have patented this. And if you put someone there again who has no idea what cars have a heated car seat, yeah, well, you screwed basically everyone else. Nintendo's US patent has implications far beyond domestic developers. The moment a game enters the US market, it becomes subject to US patent law, regardless of whether the developer is based in Europe, China, or Japan. Smaller developers are the most vulnerable. Big companies like Sony or Microsoft can defend themselves within their own patent portfolios, but startups and indie studios face a chilling effect. Yes, there it is again. The key to maintaining a healthy competitive industry, Müller emphasizes again here with an Ü, is awareness and proactive defense. Other developers should actively monitor major players, submit prior art to patent offices, and challenge overly broad patents. That's how you prevent these issues from becoming standard practice. And again, we have this one. We already talked with a couple of people in the comment section in prior videos with the loading screen mini games that were patented by, oh, I forgot, was it Bandai? I think it was Bandai. I might be wrong here, please correct me. And the patent, or when was it? 10 years ago. Everyone could use it again, but we still don't have mini games and loading screens, not only because loading screens are becoming shorter and shorter depending on the game, but also, I don't know, there are probably more reasons for that one as well. But totally different thing. For gamers, he advises staying informed and understanding of changes in titles like Palworld, which may be driven more by litigation than design. Lest we forget that not too well received update that broke the game at first. I can't remember what that one is. In the end, Müller's point is clear. Broad patents can provide leverage, but they don't have to hold back innovation in gaming so long as the industry remains informed when it comes to cases like this. The Nintendo versus Pocket Pair case will continue to be closely watched, especially if Nintendo decides to pursue it in the US. Whether the latest patent will actually be used in legal actions is still up in the air. Good article. Very good article. Thank you, Jennifer. Again, I still have to watch the rest of Fritanga's video. I will link the article and again everything that I'm showing you in the description box below. The other thing we have here, again, I usually never use X Twitter, but the time has come for me to look at least for some things. I will just link you Florian's account. That makes it a little bit easier. So the poor reporting is on Verge's Tom Warren's part, not Genbox 360's or mine, whatever there happened. But I already heard that Nintendo content creators are, of course, defending Nintendo. Because, no, Nintendo did not patent summoning. Yes, they did. But yeah, doesn't matter right now. Those people are just... yeah, I'm not saying the word. The article says Nintendo patent does involve summoning and battle mechanics, but it's more specific than that. The screenshot shows my article did explain the specific. A US patent litigator quoted by IGN agreed with us. Here are Verge's other mistakes. So, as you can see, there is not that much. Oh yeah, there it is. No, Nintendo and Pokemon did not patent summoning characters and making them battle. I've seen plenty of poor reporting on this over the past week. Yeah, Tom. I'm not so sure about that, but you lost a lot of credibility there. Yeah, well, at least, again, for people whose brains are working. Number one, no one would recite an entire claim or describe all parts of a claim in a headline. The headline was accurate that it's a patent on summoning a character and letting it fight, which does not mean that the claim says summon and fight. Okay, yeah, fair. Second, even the specific combination of things that the patent claims relates to are found in countless games. You summon a character, and depending on whether it appears right next to the enemy or not, you may have to direct it toward the enemy. Yes. Third, they say that much themselves by quoting someone who says StarCraft already did all of that. Did StarCraft do that? Where was that in StarCraft? Damn, it's been... oh, the Protoss ships. Because you have to build the small attack flyers with the big battle barges that you have. Yeah. I think that counts as summoning. Number 4. The quote about StarCraft is wrong. However, StarCraft does not have the character-sub-character distinction you find in Pokemon-style games. In StarCraft, there is no single-player character with sub-characters as covered by the patent. Instead, all units that the player creates in the game are playable characters. So much for the expert the Verge relied upon. Okay, I was also wrong. But I'm really interested if the battle barge of the Protoss counts like that. That would be good to know. Number 5. They say that yes, actually, it's right that the patent is concerning, but then they say one shouldn't worry because it could be easily invalidated. Incompetent statement. And how does that make any of the reporting poor? Especially reporting that mentioned the fact that patents can be revoked. At GamesFray said this. This patent could be revoked, but it's not easy. The USPTO, under its current leadership, makes it increasingly difficult to challenge granted patents since June 27, 2025 IP Fray article. Oh, that is interesting. That is really good to know. It's easier said than done to take down a US patent. At the moment, there is a high rate of discretionary denials of PTAB IPR petitions, whatever that is. The most popular way since the early 2010s to challenge US patents, discretionary denial means they don't even want to assess the merits. There's also the possibility of suing in court, but if the case ends up before a jury, the statistical probability of jurors considering the patent invalid is rather low. Oh, is that so? That is interesting. Anyone who's ever followed a US patent trial knows how hard it is, starting with the fact that jurors are shown a video that presents the USPTO as extremely competent. Of course they do. making it less likely that jurors believe the USPTO made a mistake. Damn, okay. That is rough. That is really, really rough. But also, again, thank you, Florian Mueller. I still hope that your name is German. Is there anything that's... Okay, Florian for gamers. Aww. Yeah, maybe. Then we have also this one. Wait, what was this? Why did I put this one up? Yeah, that's why. Again, I'm really not used to X and Twitter. Florian Müller had retweeted from Windows Central Gaming. Nintendo tells a Japanese court that mods shouldn't count as prior art. Experts warn this could let companies patent mechanics pioneered by modders. That is also incredibly scary. When big companies can just say, no, mods do not count. Those are not art. Dude, of course this is art. Someone did this. Someone made this with their own hands. This is the Tony Stark meme. They made the mod in a cave with scraps. Just because they did not work for Nintendo, for Sony, for Microsoft, doesn't mean that modders do not count. Modders did a lot of good things for the gaming industry. Just look at pathetic Bethesda, with all of their games relying on modders. But yeah, these are just my thoughts. And again, I'm really grateful to Jennifer Young, who wrote the article last week, and I'm incredibly grateful to Florian Müller. Okay. To clarify everything here, again, everything will be in the description box down below, as also Fritangaplays was the name, that video as well, because the first half was really insightful, and I think the second half will be as well. Please leave your thoughts and questions in the comment section down below. I'm keen to know what you have to say. And while you're here, please remember to do all the things that make the dings. Why? Because that way we can build a bigger community and talk more video game news every day. And by that I of course mean like and subscribe, and if you want you can share this video with your friends. And please turn off YouTube's restricted mode. Otherwise, have a great day, my friend. Stay fantastic, stay hydrated, and I will see you tomorrow with the next video. Bye, bye, bye.